Hey guys, my name is Shashwat and I'm a legal intern at LEXIS and COMPANY. In this video, I'm going to talk about the section 462 of Indian Penal Code and the criminal trespass. So, the major reason for having laws in the country is for protection of life, liberty, and property of all the citizens, along with maintaining peace in the country. India for penal laws follows Indian Penal Code that came into existence in 1908. Oh, sorry, that was the Code of Civil Procedure. Indian Penal Code came in 1860. One of the most important aspects of the Indian Penal Code is to ensure that the right to property of the individual and also to restrain individuals from interfering and damaging the property of others. For the same reason, the concept of offences against property was added in the penal code, and the topic of criminal within. So, the section 462 of IPC tells us about the concept of trespass, which was introduced as a breach of peace of an individual. Until the law was stated, trespass was not considered to be a crime for the general public. In the early common law, criminal trespass was unknown. The statutes under which sit-in demonstrators have been arrested and convicted, while virtually identically in effect, vary greatly in their wordings. At that time, criminal trespass were not accepted, as it was stated that these laws coexist with the racial discrimination laws. To make criminal trespass as a part of current legislation, the court was in need of valid reasoning and agreement. The court said that they are open to take into account possible applications of the statutes in other factual contexts. In many jurisdictions, the crime of trespass still has many common law elements in early England. This section we are dealing with here, section 462 of IPC 1860, is related. The section makes a person liable of if a property is entrusted with him and he tries to open the receptacle containing property with intent to commit the mischief of dishonesty. The elements of section 462 of the Indian Penal Code are that there was receptacle closed or fastened, the accused was entrusted with the receptacle closed or fastened and had no right to open the receptacle. Also, it contained property of accused, believed that it did contain a property. The accused breaks open to unfasten it. The accused did so dishonestly or with an intent to commit mischief. And that was last. Then comes the origin of trespass in the common law. The concept of trespass originated in England, as I said before. Actually, that was dated back in 13th century that it came into existence. The main emphasis was on the providing of civil remedies, such as the payment of damages or return of possession, as there was no clear distinction between the civil and criminal wrong. Parliament adopted criminal statutes in the late 14th century prohibiting forcible entry on real property. This legislative scheme was further developed in the next 2.5 centuries, primarily to provide for return of possession and to prohibit forcible determiner who refused to leave the property. Then this development took a long time because of a variety of factors. such as the existence of similar remedies, the availability of the legislation concerning the forcibly entry and detainer, the failure to remedy certain conditions such as general weakness of the executive breach of government. So it took much time. The common law of criminal trespass was introduced to protect against the intruders who poach, steal livestock and crops, or vandalize property. Under the common law, an action for trespass was trespass for to goods lay for intentional and direct interference with another possession of goods. Thus, it is the interference of possession and not the title of the goods. There is no requirement to the claimant should suffer any damages. So, I may conclude by saying that a person may be entrusted with the closed and receptible for any person for any purpose, whether by way of security or by safe custody. In either case, if it is closed and deposited, the depositee has no right to open it, but if he opens it, he commits no offense under his intention. So, if however he is given authority to open it, his opening it dishonestly is not punishable, though he would of course be liable under the general law for any offense he may commit respecting it. Thank you.